DeLeone Cianciella. I think I'm live. Hold on. Okay. Why am I not showing up? Well, there I am. Let's go here. Why am I not showing up? Oh, there I am. Let me there I am. Mute that. Click here to join. Go here. Put this here. Hello, Noel. Getting ready for my restoration class. How are you? Oh, fresh braids, yo. Fresh braids. I'm just kicking it. Waiting to start my restoration class. Go from there, clean up a little, go from there. Here we go. Hello?
Hello, can you hear me?
I can hear you. Can you hear me?
Yeah, I can hear you. There we go.
All right, let me shut the outside construction noises. Whew.
How are things going?
Good. All right. So I was wondering, because of my new job, can these be weekly or do they have to be twice a week?
For right now, they have to be twice a week.
Okay.
I have a little bit more availability in my schedule. We might be able to do earlier.
Well, that's the thing. I don't know. With my IATSE job, my schedule changes. So I have to basically call them after this to hit up for the rest of the week because I can't work Monday or Wednesday. And sometimes the jobs will last an entire week. And so
Right.
I was wondering if I could also do them from my phone. Like, let's say I was at the job and I was like, well, hey, I have to take this half hour off at this time. And then do them through my phone.
Yeah, I don't see why that would be an issue. As long as you're in a comfortable, safe place that you feel you can do the class, then where you do it is none of my business. So.
Alrighty. Yeah, because I got a call. I think it was yesterday, seeing if I could head out to work, and I was like, I have a class from 2:30 to 3 on Wednesday, and the guy was like, well, give me a call after your class because all the stuff we got right now is all week long, and it's during that time.
Yeah.
Yeah. So
I might be able to get it down to once a week, but I don't want to promise anything. So let me look into it and see what we can do, and then I'll let you know. But for now, we'll stick with the 2 times a week.
Alrighty.
I did find a good video for us to watch today. I thought it was interesting, so
Alrighty.
Okay, do you see the screen?
Yes. Confidentiality 1.6.
Perfect. Confidentiality. Rule 1.6 sets forth the attorney's ethical obligation of confidentiality. The first thing to know is what the obligation covers. It covers everything the lawyer learns as a result of her representation of the client. Everything the client tells the attorney, everything the attorney learns about the client's matter as she investigates the case, any information which the attorney possesses related to the representation is covered by the attorney's obligation to maintain confidentiality. Comment 2 sets forth the rationale behind attorney-client confidentiality. A fundamental principle in the client-lawyer relationship is that the lawyer must not reveal information related to the representation. This contributes to the trust that is the hallmark of the client-lawyer relationship. The client is thereby encouraged to seek legal assistance and to communicate fully and frankly with the lawyer, even as to embarrassing or legally damaging subject matter. The lawyer needs this information to represent the client effectively and, if necessary, to advise the client to refrain from wrongful conduct. The ethical obligation of confidentiality is different from privilege, which is a part of the law of evidence. As comment 3 explains, attorney-client privilege and the work product doctrine apply in judicial proceedings in which the lawyer may be called as a witness or otherwise required to produce evidence concerning a client. As compared to confidentiality, only certain things are privileged. For example, private attorney-client communications for the purpose of obtaining legal advice are privileged. The attorney cannot be forced to disclose the content of the communication and should, on the client's behalf, assert the privilege if called to testify. There are certain exceptions to the attorney-client privilege. One relevant exception is the crime-fraud exception. If the attorney-client conversation was held to aid in an ongoing or future crime or fraud, the conversation is not privileged. The following conditions must exist for the crime-fraud exception to apply. 1, the client must have an intent to commit a crime or fraud, whether the lawyer knows of this intent or not. 2, the conversation must be in furtherance of the crime or fraud. And 3, the party attempting to pierce the privilege has the burden of proving the crime-fraud exception. This is a high burden because we want clients to be able to consult with their lawyers about their plans, and society hopes the lawyers will dissuade the clients from carrying out activities that are criminal or fraudulent. There are also ways in which the attorney-client privilege may be waived. For example, if the attorney-client communication is in the presence of a third party, the privilege is waived. The privilege is also waived if the client and the lawyer fail to assert the privilege, or if the client consents to disclosure, or if the client discloses the communication to unprivileged third parties. You will learn more about attorney-client privilege in evidence class. However, for this class, it is important to note that none of these exceptions to privilege or waiver of privilege change the lawyer's obligation of confidentiality. Thus, if the client's friend sits in on an attorney-client conference, the friend could be subpoenaed and asked what the client said. However, the lawyer would still have the obligation to keep confidential what she learned, even if the attorney-client conference was not private. It is most important to remember that confidentiality is much broader than privilege. As comment 3 concludes, the confidentiality rule applies not only to matters communicated in confidence by the client, but also to all information relating to the representation, whatever its source. There are limited exceptions to a lawyer's duty to maintain confidentiality. First, the client may expressly or impliedly waive confidentiality. The client may give informed consent, after counseling, for the lawyer to share confidential information. For example, the client who wants his attorney to negotiate a particular outcome may explicitly say that the lawyer is permitted to share certain material facts with the opposing party in order to negotiate on the client's behalf. Similarly, the client may have impliedly given the attorney permission to share the facts that would be relevant and necessary to negotiate the matter.
Rule 1.6b explicitly states that the lawyer may reveal otherwise confidential matters, quote, to the extent the lawyer reasonably believes necessary under certain limited set of circumstances. One circumstance is to prevent reasonably certain death or substantial bodily harm. For example, if the client credibly tells his attorney that he is going to kill his estranged wife when he is released from jail, this exception would permit the lawyer to take protective action. This exception recognizes the overriding value of life and physical integrity and permits disclosure reasonably necessary to prevent certain death or substantial bodily harm. See comment 6. Can you think of other scenarios in which the lawyer may want to reveal confidential information to, quote, prevent reasonably certain death or substantial bodily harm, close quote. Note, however, that this is permissive. The lawyer may reveal. The rules of professional conduct do not require the lawyer to turn his client in. Other law may do that. For example, child abuse reporting statutes may require anyone having reason to know a child is abused to report that to the Child Protective Services. Comment 12 notes that while other law may require an attorney to disclose information about her client, whether that other law supersedes Rule 1.6 is a question of law beyond the scope of these rules. The scope note states that, quote, the rules presuppose a larger legal context shaping the lawyer's role, and that context includes substantive and procedural law in general. Thus, a lawyer may have a statutory requirement to report on his client, but this question must be answered after researching that law. It is not answered by the rules. A second exception to confidentiality is to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, where the client is using or has used the attorney's services to carry forth the crime or fraud. The lawyer is permitted to blow the whistle on his client here because his services have been used in furtherance of the crime or fraud. As comment 7 notes, such a serious abuse of the lawyer-client relationship forfeits the protection of this rule. This comment also references Rule 1.2d, which prohibits the lawyer from assisting in a client's crime or fraud, and Rule 1.16, which requires or permits the lawyer to withdraw from representing the client. Thus, the lawyer who discovers his client is using his services to commit a crime or fraud has all three things to think about: whether to blow the whistle on his client, how to avoid becoming implicated in the crime himself, and whether he needs to or should withdraw from further representation. The third exception is related. Again, where the client has used the lawyer's services in furtherance of a crime or fraud, and the lawyer may still prevent, mitigate, or rectify substantial injury to the financial interests or property of another that are reasonably certain to occur, the lawyer may breach confidentiality to do so. This exception applies when the lawyer does not learn about the crime or fraud until after it has occurred. It applies when the loss can still be prevented, mitigated, or rectified. Here again, this is permissive. A lawyer may choose to do this or may choose not to. Other law may exist that could require the lawyer to blow the whistle on the client where the lawyer's services have been used by the client to perpetrate a crime or fraud. Note that these exceptions in Rule 1.6b 1 through 3 do not permit the lawyer to reveal the client's confessions to a past crime or fraud. Instead, their focus is on preventing the crime or preventing, mitigating, or rectifying the injury when there is still time to do so. These rules do not apply when the client hires the lawyer to represent him concerning his past crime or fraud.
It's a lot of information.
Yeah. Some of it I kind of already knew that, you know, they're supposed to keep it confidential unless it's any plot or thoughts of harming myself or others.
Yeah. I like to focus on the confidentiality piece of the case because it is a really big piece, and I don't think a lot of people kind of fully understand that there are exceptions to those things, but either way. The other thing I wanted to show you was this Quizlet flashcard study tool I found with the 12 steps of a trial. I thought it was interesting. So, step 1 explains the evidence, what is intended to be proven. It's your opening statement by plaintiff or prosecutor. Opening statements by the defense, which is step 2, explains the flaws in the prosecution's case, lays out contradicting evidence, alternate theory of crime. Direct examination by plaintiff or prosecutor. Step 3, questions witnesses, tells story of events, lay out crime and evidence to support the prosecution's theory of the case. Cross-examination by the defense, which is step 4, questions each prosecution witness, discredit the witness, and character assassination. So they're trying to knock off those witnesses so they are not admissible to the jury. Motions, step 5, the longest step, usually made by the defense to suppress evidence / witness testimony. Direct examination by defense. Step 6, questions each of the witnesses, tell a story to why the defendant did not commit the crime, creates a reasonable doubt. Cross-examination by the plaintiff or prosecution. Step 7, question defense witnesses, discredit those witnesses. Closing statement by plaintiff or prosecution. Step 8, review evidence, recap witness testimony, review everything for the jury, and ask for a guilty verdict. Step 9, your closing statement by the defense, point out errors in the prosecution's case, create reasonable doubt, find unkept promises to prove made by the prosecution, and then ask for the not guilty verdict. Step 10, rebuttal argument, plaintiff, prosecution, closing remarks can only address points raised in the defense's closing. Step 11, jury instruction, judge reviews all laws with jury and what they can convict defendant of possible punishments. And step 12, your verdict. Go ahead.
Step 11 says possible punishments. I thought the jury's not allowed to know the possible punishment in the state of Colorado.
That might be the case. I don't know what state this was made for.
Okay.
They don't give a whole lot of detail. You're probably right. They probably can't know that in Colorado. So we can just forget that little piece.
Alrighty.
Step 12, verdict, unanimous decision required for conviction. No unanimous decision results in a mistrial or a hung jury. I just like this. I think it breaks it down a little more than, I don't know if you remember in Module 5, the burden of proof.
Yeah.
Where it has the...
I can go to it, but yeah, this is a little more in depth. I mean, it does break it down step by step, and each step kind of states what it is, you know. Direct examination by defense, cross-examination by plaintiff or prosecution, closing statements.
Yeah, so I like this a little bit more because it's not as broad as the other one.
Yeah, this is more intricate. Hello?
Yeah.
Oh, okay.
I'm still here. Yeah. Do you have any questions about that or any comments or?
No, that's actually pretty, the way they put stuff out is really easy to be understood. I actually just subscribe to the Center for Innovation in Legal Education.
Oh, okay.
Yeah. I mean, you know, the other one that you put on, I also subscribe. So, you know, the fact that these are here and when you look at them, some of them have the, it's basically almost like teaching a lawyer how a lawyer is supposed to understand the law also.
Yeah, I think it's interesting. A lot of that is I feel like they just break things down into a little more, less legalese.
Yes.
But that is all I have for you today. We can plan on meeting next week.
Monday is a
and
holiday, I believe. Columbus Day, Indigenous Day.
We are not closed.
Okay.
So we'll still have class. Yeah.
Alrighty.
Unfortunately, but
I was just wondering.
no worries. Thanks for asking.
So 2 Mondays ago, I went and I spoke to the Denver City Council about working with the government to head a task force to proactively prevent school shootings. And I honestly was expecting somebody to call me, at least somehow, you know, and some people were wondering how I didn't get arrested or anything. I don't know why they were thinking that. But, you know, I just thought it was odd that, you know, I just got stonewall and no response whatsoever, like ghosted, you know. I sent the email to the FBI that interrogated me about that kid shooting up at school and allegedly me recruiting him for Wagner. And I just thought that was, you know, I thought at least somebody would have at least told me no or which direction to go. But the whole cold shoulder and just completely ignored from it seemed a little odd.
Oh, I see.
Because when I was on federal supervised release, parole, probation, when I got out of prison, whatever you want to call it, I actually did some of that. They actually gave me their files and asked me to go through them. One of them was a hand-drawn, this girl had to do a family portrait. So in her art class, everybody just drew their, like a picture, took a picture of their family and copied it. This girl actually did a hand drawing of every school shooter as a family portrait hanging out together. And Miss Laura Ansart, my PO, she asked me if I knew any of the people in there. And I was like, these are all school shooters. And I pointed out each and every one from what school shooting they did, from I think it was the Asian dude in Princeton to some other girl who shot up the elementary school across from her home. And they actually gave me a file to look through and say, which one of these do you think would actually do it? And I put one to the side, some to the middle, and some to the other side. And I said, I honestly think this one is a threat. This is the one you got to listen to. And they're like, but this is the least one. And I was like, but if you read the report, it states that this anonymous tip or whoever, because they black it out, reported that this person overheard a suspected shooter claiming that they were going to go out and do it, and then got real quiet after they said it. And on the other side was a stack of papers where it was basically people running their mouth talking about how they've been talking about it for months. You know, I'm going to go shoot this motherfucker. I'm going to go shoot up this fucking their employment. And I was like, well, this one sounds like they're just talking about it. This one over here sounds like he accidentally mentioned what he was planning on doing. And the feds actually took my advice, went out there and took care of it, you know. And then when I spoke to the judge about it, you know, she was like, one, you were never supposed to see those files. And two, we're not allowed to discuss it with you anymore. And then when I asked, I was like, well, hey, I've been doing this with you guys for like 2 or 3 weeks. What does it take to actually form a special task force to proactively prevent school shooters? And I was basically told, eat a dick. You know, I don't know how else to say that. So, you know, I just thought, honestly thought at least like the FBI would hit me up and say, no, thank you, or something besides the cold shoulder. But,
Yeah.
and, you know, I was wondering, did anybody contact you? Because I know every time I write a letter to the government or something, it always goes to the court or to the judge or to a lawyer, and then I have to discuss it.
No, I haven't received anything like that.
Okay. It's been over a week, so, you know, I just thought I'd bring it up just in case.
Gotcha. Yeah, no, I I haven't received anything like that. I don't even know if it would come onto my desk or anything like that.
Okay. Well, alrighty. Well, I got to call the IOTSI dispatch to get on the schedule for tomorrow and the rest of the week. And so I will see you Monday at 2:30 then.
Alrighty, sounds good.
You have a beautiful weekend.
You too, thanks.
Peace. Alrighty, let's click out of this Teams thingy. All right. Wow, we got some chats going on. Hello, everybody. How are y'all? Green Steak, no, hello. Will, hello. Eddie M, hello. All right. He records the whole call anyways. What's the difference? Well, streams, yeah. You know, I think that's referencing me getting a new schedule based upon my new work schedule, a new restoration class schedule based upon my new work schedule. All right. Is this chick hot? I'm not commenting on my counselor. Sounds like she moderately shaves her, whatever. Okay, no, I want moderately shaved. Will? Alrighty. I'm getting a free education. Yep. She talking about Natalie. I think I know where that comes from. That comes from the where they're talking about child abuse, right? Yeah, that's right, Eddie. It's her job to revoke PIP benefits. I don't know what PIP benefits are, as Will would say. Oof. Hello, Will from Green Snake. I know, right, Eddie? Imagine getting paid to extract public assistance. Several people do. Eddie and picture. Snake pizza. Is date really me speaking? Is that really me speaking 75? Blower a kiss. No. Yummy pizza. Ewok owns this channel. I had pizza for supper. My oven still does not work. I have to go down and speak to them about that. Picture what? Me speaking. Ewok always what wins? Yeah. I think you forgot 18 what wins. I think that's what you meant. I heard Ian is also affiliated with Wagner Group. Him and Brooklyn Chick's son are in Ukraine right now working with them. Can I get a contact info? Oh, you could talk to her. Spooky girl, hello. Unfortunately, Kenny, you're probably not the weirdest person who took the stage that day. They're numb to it. Yeah, you're right. Would. Yeah. Okay. So hey everybody. It's 2:58 p.m. I gotta call the IOTSI dispatch. And look at my app. All right, so I'm gonna call this. We're, I don't know, almost 30 minutes into this. I'm hungry. I haven't eaten all day. I ate like one little bar of food. I went, got my hair did. I woke up, took the shower, got the hair did, went down to the fucking dollar store. They're all out of do-rags. Okay, flexible dates. October 5th, that's tomorrow. So yeah. I'm checking this out. So look here, Mass, promote Gotham Greens, Bellagio cheese. Oh my fucking god, dude. Oh, there's a phone call. Oh, all right, I gotta go. Everybody, I'm gonna call it. Peace. Love you.